Hi, friends. Breaking news this week in the United States of America. You probably heard it, but the Federal Trade Commission has ruled that non-compete agreements are unenforceable. So gosh, what does that mean? If you were asked to sign a non-compete as part of your employment, does that mean you just get to scratch that part out of your contract and deem it void? Nope, probably not what this means. So let's do some quick legal studies. And that starts with the Federal Trade Commission. Who are those 5 people and why do they get to change state laws? Well, the Federal Trade Commission has been asked by Congress to come in and regulate trade. In this case, they think that means getting involved with unfair trade provisions. And when you read the actual rule itself, it doesn't apply to these areas. Number 1, senior executives. Number 2, franchisees. Number 3, sale of business. Number 4, doesn't impact your non-solicitation agreements. And number 5, doesn't apply to some nonprofits. So why do nonprofits get a pass? Well, there's an argument, a very good argument, that the Federal Trade Commission doesn't have the right to regulate nonprofits because of the founding documents were for profits. So what on earth is this law going to do? Does the Federal Trade Commission really have the power to ban non-competes? They think they do. Is it a stretch? Probably. Traditionally, this is an area of state law, not federal. It only becomes federal when there's state commerce and interstate commerce involved. So maybe Congress has the right to create a federal ban on non-competes, but a federal agency, the courts will decide, and it will be a long and nasty legal battle. So really, what is the upside of this if you're an employee? I'll tell you the upside, because people are finally talking about non-competes. And I think with pressure from employees, there will be fewer non-competes. And some people will refuse to sign non-competes. And states that innovate will quickly become ahead of the curve. Virginia being one state who has a law regarding low-wage employees, but not hospital employees, medical providers, etc. And I think what will happen, since some nonprofits, like most hospitals in my area, are allowed to have non-competes, but the for-profits aren't, they might lose some good doctors to the for-profits. So I think non-competes stink. I think anything that allows people to have a conversation about them is a good thing, and I think it's about time that we started talking about this politically. Is this going to be the rule that changes all that? I doubt it, but maybe it will change the culture.